The ruling that shook the nation. The Supreme Court has just delivered a ruling that will echo through every state house, courthouse, and gun store in America. In a 6-3 decision, the court has drawn a line between individual liberty and government control, forever changing how concealed carry is defined across the United States. For millions of gun owners, this isn't just another headline. It is the legal earthquake that shifts the entire foundation of the Second Amendment debate. What started as a single lawsuit has now turned into a nationwide moment of reckoning. So stay with us as we break down what this ruling really means, how it will affect your rights, and why the reaction from lawmakers across the country is unlike anything we have seen before. Before we begin, make sure to subscribe to Survival Lawline and share this video with every gun owner you know. Here, your rights come first, and the truth never gets buried. Chapter 1. The case behind the 6-3 decision. Every major legal shift begins with one challenge that dares to question the status quo. This one came from a lawsuit filed after several states introduced public safety zones, restricting concealed carry in parks, churches, and private businesses. The plaintiff argued these laws directly defied the Supreme Court's 2022 Bruen precedent, where the court struck down New York's proper cause requirement for carry permits. This new case reached the court under the name Moore v. Harper, 2025, and its outcome has now reshaped the meaning of constitutional carry. Key points. The court reaffirmed that the Second Amendment protects the right to carry a firearm in public for self-defense. It declared that states cannot impose broad, sensitive place bans that effectively nullify that right. It established a new three-part test for carry restrictions: historical basis, narrow scope, and objective licensing standards. Chief Justice Roberts joined the majority opinion, signaling the court's commitment to clarifying Bruen rather than reversing it. This case in this 6-3 split marks the moment when the court told state governments, "You've gone too far." Chapter 2. How we got here. From Bruen to Moore. To understand why this decision is so important, we have to look back. In New York State Rifle and Pistol Association v. Bruen, 2022, the Supreme Court first established that the Second Amendment is not a second-class right. That case overturned New York's subjective proper cause requirement for carry permits and set a new standard. The government must justify firearm restrictions by pointing to historical tradition. But after Bruen, many states responded by creating workarounds, passing laws so restrictive that they effectively replaced the old ban with a new one. Key points. New Jersey, Maryland, and California created extensive gun-free zones covering most public areas. Illinois and Hawaii introduced permit rules requiring interviews, references, and insurance barriers that made permits nearly impossible to get. Several federal courts upheld those laws, arguing Bruen left room for local discretion. That conflict between circuits is what forced the Supreme Court to step in again and to speak more clearly this time. When Moore v. Harper landed on the docket, gun owners knew the court had a chance to either strengthen or soften Bruen. It chose the former, and the result was a 6-3 ruling that now defines the modern era of concealed carry. Chapter 3. The majority opinion. What the court actually said. Justice Thomas delivered the majority opinion, joined by Roberts, Alito, Gorsuch, Kavanaugh, and Barrett. He wrote that the Second Amendment does not permit a government to transform a right into a privilege by merely shifting the burden of proof. That line alone will echo in every courtroom for years to come. Key points. The court reaffirmed that the text, history, and tradition standard from Bruen still controls. It ruled that modern policy concerns cannot erase historical rights. States must show a clear historical analog before restricting carry in any specific place. Permitting systems must be objective, no discretionary approvals based on sheriff opinion or political bias. Thomas also pointed out that constitutional rights cannot depend on the whims of local officials. With that sentence, the court ended the era of may-issue interpretations once and for all. Chapter 4. The Dissent. Why 3 justices disagreed. Not everyone on the bench saw it the same way. Justice Sotomayor, joined by Kagan and Jackson, issued a strong dissent, arguing that the majority had handcuffed state governments in their duty to protect public safety. She warned that the decision invites chaos by removing centuries of regulatory flexibility. Key points. The dissent claimed the majority ignored modern conditions of violence unimaginable to the founders. They argued that the historical test is too rigid and limits legislative innovation. They believe the court should defer to states on matters of public safety and licensing. They warned that more guns in public could lead to increased risk of confrontation. It's a familiar divide between individual liberty versus government control, but this time the majority opinion carried the day, and its legal weight will be felt in every federal appeals court across the country. Chapter 5. What this means for concealed carry nationwide. The moment this decision was released, attorneys general from California, New Jersey, and Maryland went into emergency sessions. That's because the court just invalidated large portions of their current carry laws. For gun owners, this ruling does three major things. Key effects: it makes shall issue the national standard, permits must be granted if legal criteria are met. It strikes down broad, sensitive place zones that blanket entire cities or public transport. It forces states to rewrite their licensing laws to meet historical standards of regulation. It opens the door for hundreds of lawsuits to be filed by gun rights organizations nationwide. In practical terms, this means millions of law-abiding citizens will soon see easier access to concealed carry permits, and some states may eliminate permits entirely. The court has drawn a clear line. The Second Amendment protects the right to carry a firearm for self-defense, and no bureaucrat can rewrite that truth. Chapter 6. The states already in defiance. While the ink on the Supreme Court's opinion was barely dry, several states began preparing to resist. California, New York, and Maryland have already hinted that they will pass new public safety legislation to preserve their existing restrictions in different forms. Instead of direct bans, they are planning to regulate around the edges using taxes, zoning rules, and civil penalties to make lawful carry nearly impossible in practice. This has sparked a new wave of lawsuits that could soon return to the federal courts. Key developments. California's Attorney General announced plans to introduce sensitive zone redefinitions, hoping to reclassify nearly all public venues as restricted. New York legislators are exploring insurance mandates and data registration for permit holders. Maryland has drafted a new licensing bill that requires yearly renewal and psychological evaluations. Several sheriff's departments have already declared that they will continue enforcing existing bans until new guidance is issued. Legal analysts are warning that these states are walking a thin constitutional line. The Supreme Court's majority opinion clearly warned that workarounds designed to chill the exercise of a right are violations of that right itself. If these states follow through, they could face direct contempt motions or emergency injunctions within months. Chapter 7. The DOJ's possible next move. The Department of Justice now faces a dilemma. On one hand, it has an obligation to respect Supreme Court precedent. On the other, the administration faces intense political pressure from several governors demanding federal assistance to preserve their gun restrictions. Inside the DOJ, sources have described quiet meetings focused on guidance memos that could reinterpret portions of federal firearm law to give states more discretion. But such a move would likely trigger immediate legal challenges from gun rights groups. Key expectations. The DOJ could issue a memo limiting how federal agencies interpret public carry rights under federal jurisdiction. They might also delay enforcement of the ruling by asking for clarifications in lower courts. Pro-gun organizations like the Firearms Policy Coalition and Gun Owners of America are already preparing counterfilings. The Supreme Court may have to intervene again if the DOJ's interpretation conflicts with this ruling's intent. If that happens, the fight will no longer be about one law or one state. It will become a national debate over whether the federal government can reinterpret a constitutional right after the court has already spoken. Chapter 8. The ripple effect on future 2A cases. Every major Supreme Court ruling becomes a foundation for the next one. This 6-3 decision is now a cornerstone that will influence dozens of ongoing cases involving assault weapon bans, magazine limits, and even suppressor restrictions. Lower courts are bound to apply the same text, history, and tradition test established in Bruen and reaffirmed here. Key impacts. Assault weapon bans in Illinois, New Jersey, and Washington are now on weaker legal ground. Magazine capacity restrictions face an uphill battle unless states can show clear historical analogs. Pending NFA-related cases such as suppressor and SBR challenges may benefit from this decision's logic. The decision reinforces the idea that constitutional rights cannot be balanced away by shifting political priorities. This ripple effect will stretch far beyond concealed carry. It will reach every courtroom where the Second Amendment is being tested, and it will redefine how judges analyze gun laws for years to come. Chapter 9. How this changes everyday gun owners. For most Americans, Supreme Court decisions feel distant and abstract, but this one has immediate, visible effects that will change how millions of responsible gun owners live day to day. Under the new legal environment, several states must revise or repeal existing carry laws, meaning permit processes will become faster, cheaper, and more consistent nationwide. Key takeaways for citizens. Expect more uniform shall-issue permitting systems across most states. Local law enforcement will have less discretionary power to deny carry licenses. Laws designating entire cities as sensitive places will be invalidated. Reciprocity between states may expand as laws become more standardized. For concealed carriers, this decision represents clarity after years of confusion. The right to bear arms for self-defense is no longer a privilege that depends on geography or politics. It is once again recognized as a national standard rooted in constitutional law. Chapter 10. The Political Aftershock. As expected, the political fallout has already begun. Senators, governors, and advocacy groups on both sides are using this decision to rally their bases ahead of upcoming elections. For conservatives, it is proof that the judiciary still honors the Constitution. For progressives, it is a call to fight for new legislation through Congress. Immediate reactions. Several state attorneys general announced plans to propose a Federal Carry Oversight Act. Presidential candidates have begun referencing the ruling in speeches about individual freedom. Polling shows an immediate divide, with nearly 70% of gun owners supporting the decision, while 60% of anti-gun voters call for legislative counteraction. Gun rights organizations have launched campaigns encouraging citizens to understand their new protections. This political clash is not temporary. It signals a long-term battle over how far the federal government can go in limiting a right the Supreme Court has now reaffirmed. The turning point in American liberty. What the court has done is more than issue a ruling. It has drawn a clear line between fear and freedom. For decades, millions of responsible gun owners have lived under a patchwork of confusing, often contradictory state laws. Today, that begins to change. The Supreme Court has spoken again, reminding every politician in America that constitutional rights do not fade with public opinion. But this story isn't over. States will resist. Lawsuits will continue. And the Department of Justice may still try to reinterpret the boundaries of this ruling. That is why it has never been more important for citizens to stay informed and engaged. At Survival Lawline, we are here to break every major legal update, explain what it really means, and stand firm for truth, law, and liberty. If you value your rights, share this video, subscribe, and join the growing community of Americans who believe that freedom is worth defending one case, one ruling, and one truth at a time.